The United States entered uncharted constitutional territory on Wednesday afternoon after a federal judge issued an extraordinary referral to Congress, citing what she described as repeated violations of court authority by a former president and concluding that judicial remedies alone may no longer be sufficient to protect the integrity of the legal process. The 47-page filing, signed by U.S. District Judge Tanya Chutkan and transmitted to Congressional leadership shortly after 3:17 p.m. Eastern Time, outlines a pattern of conduct that, according to the court, raises profound concerns about obstruction of justice, witness intimidation, and defiance of lawful court orders. While federal judges routinely sanction defendants through fines, contempt citations, or pretrial detention, legal scholars say this referral represents a rare and consequential escalation, one that shifts responsibility from the judiciary to the legislative branch at a moment of intense political polarization. The document does not itself initiate impeachment proceedings, nor does it carry criminal penalties. Instead, it formally notifies Congress that, in the court's view, traditional judicial enforcement mechanisms may be inadequate given the defendant's political influence, public reach, and demonstrated willingness to disregard court-imposed restrictions. "This is not a ruling in the conventional sense," said a former federal prosecutor familiar with judicial discipline procedures. "It is a statement that the court believes the constitutional system of checks and balances must now engage at a higher level." The referral arrives against the backdrop of a prolonged legal confrontation between the former president and multiple branches of government. Over the past several months, Judge Chutkan has overseen proceedings marked by repeated disputes over compliance with gag orders and pretrial conditions designed to protect witnesses and preserve the integrity of the judicial process. According to the filing, the court documented 14 separate instances in which it alleges court directives were violated. These incidents are supported, the judge wrote, by transcripts, contemporaneous screenshots, and sworn testimony. The conduct described includes public statements targeting individuals identified as potential witnesses, commentary that the court argues could prejudice jurors, and private communications, some of them recorded, in which the former president is alleged to have discussed strategies for bypassing court restrictions with advisors. The judge emphasized that her conclusions were based not on political speech alone, but on evidence suggesting deliberate and coordinated actions taken with knowledge of existing court orders. "This distinction is critical," said a constitutional law professor at Georgetown University. "Courts are extremely cautious about restricting speech, particularly political speech. What changes the analysis is intent and coordination, especially when speech becomes a tool to obstruct judicial proceedings." Why the court took an unprecedented step under normal circumstances, repeated violations of court orders can lead to escalating sanctions, including detention. However, the filing argues that such remedies carry unique risks when applied to a former president who remains a dominant figure in national politics. Judge Chutkan outlined what she described as a constitutional dilemma. Imposing traditional penalties could provoke unrest, undermine public confidence in the judiciary, or be framed as political persecution, while failing to act could erode the authority of the courts entirely. The judiciary derives its legitimacy from voluntary compliance with its orders, the filing states. When a defendant demonstrates the capacity and intent to defy those orders without consequence, the court's authority is not merely challenged, it is negated. By transmitting the record directly to Congress, the judge effectively invoked the constitutional mechanism designed to address misconduct by senior federal officials when ordinary legal tools prove insufficient. "This is the judiciary saying, 'We have reached the limits of our institutional power,'" said a retired federal judge. "That is not something judges do lightly." Reaction on Capitol Hill was swift and uneven. Democratic leaders acknowledged receipt of the referral and confirmed that legal staff were reviewing the material. Several senior Democrats characterized the document as serious, substantial, and deeply concerning, while stopping short of committing to specific procedural steps. Republican response has been more fractured. Some members dismiss the referral as judicial overreach, accusing the court of inserting itself into the political process. Others, particularly lawmakers from competitive districts, struck a more cautious tone. Represher Don Bacon, R.Neb, in a statement said that allegations of obstruction supported by documentary evidence must be evaluated on their merits, regardless of the individual involved. Reptor Mike Lawler, RNY, similarly emphasized that no public official is exempt from court orders. Privately, several Republican aides acknowledged that the source of the referral, a lifetime-appointed federal judge, has complicated efforts to dismiss the issue as partisan. "This isn't coming from a political opponent," said one senior GOP staffer. "That matters. The court's actions may have consequences beyond the impeachment process." According to individuals familiar with the matter, the same evidentiary record transmitted to Congress has also been shared with federal prosecutors, potentially opening the door to additional criminal charges related to witness tampering or obstruction of justice. Such charges, if pursued, would proceed independently of any congressional action. Legal experts note that impeachment does not preclude criminal liability, nor does criminal prosecution bar congressional proceedings. "This is not an either-or situation," said a former Justice Department official. "The Constitution allows parallel tracks, and that appears to be exactly what is happening. The possibility of simultaneous impeachment proceedings and active federal prosecutions would be unprecedented in American history." The situation intensified further following a series of public statements by the former president on social media platforms in which he denounced the referral and warned supporters that congressional action would represent a fundamental threat to constitutional rights. One post in particular drew immediate attention from law enforcement officials. In it, the former president referenced the Second Amendment in the context of potential congressional action, language that authorities say is being evaluated for its security implications. Federal law enforcement agencies declined to comment on specific assessments, but confirmed that threat monitoring protocols have been elevated in Washington, D.C. By Thursday morning, National Guard units were visible near key federal buildings. Temporary barriers had been installed around the Capitol complex, and additional security checkpoints were established. Officials emphasized that these measures were precautionary and informed by intelligence assessments shaped by the events of January 6, 2021. "We are not taking chances," said one senior official involved in security planning. "The lesson of the past is that rhetoric can have consequences." For residents and federal employees in the Capitol, the atmosphere has been tense. Helicopters have patrolled the airspace above downtown Washington, and law enforcement presence has been noticeably heavier than usual. Some federal agencies advise staff to adopt flexible work arrangements over the coming days. "This feels different from normal political drama," said a longtime congressional staffer. "There's a sense that multiple systems are under pressure at the same time. The memory of prior unrest looms large, and officials say that contingency planning is now a central focus across agencies responsible for continuity of government." Adding another layer of complexity, discussions surrounding the 25th Amendment have reportedly resurfaced in private conversations among senior officials. The amendment provides a mechanism for transferring presidential authority if a president is deemed unable to discharge the duties of the office. While no formal action has been announced, several sources confirmed that the topic has been raised in internal deliberations as a hypothetical safeguard. Legal analysts caution that invoking the 25th Amendment would represent an extraordinary measure and would likely provoke significant political backlash. "The fact that it's even being discussed tells you how strained the situation has become," said a constitutional historian. "It is not a routine conversation. The developments have not gone unnoticed abroad." Diplomats from several allied nations confirmed that they have sought briefings from U.S. officials expressing concern about political stability and governance continuity. Foreign media coverage has focused on the rarity of a former U.S. president facing simultaneous legal and constitutional challenges. Adversarial governments, analysts say, are closely observing the situation for signs of vulnerability. When the United States appears internally divided, it affects global calculations, said a former ambassador. Perception matters. Economic and institutional consequences. Markets have so far reacted cautiously, though analysts warn that prolonged uncertainty could have broader economic effects. Political instability has historically increased volatility in currency markets and influenced investment decisions. Beyond immediate financial indicators, experts emphasize a deeper concern: erosion of trust in institutions. The greatest risk is not short-term turbulence, said a political scientist at Stanford University. It is long-term damage to the belief that rules are enforced consistently. Several scenarios now appear plausible. Impeachment proceedings could advance rapidly in the House, with the referral serving as a central evidentiary foundation. Senate acquittal remains a possibility if the two-thirds threshold cannot be met. Criminal indictments could be filed independently by federal prosecutors. Constitutional safeguards, including the 25th Amendment, could be reconsidered if officials conclude that stability is at risk. These paths are not mutually exclusive and could unfold simultaneously. Historians caution against premature conclusions but agree that the current moment represents one of the most severe tests of cons. What makes this period distinct, said one scholar, is not just the behavior of a single individual, but the response of the institutions around him. Whether the system ultimately bends or holds will depend on decisions made in the coming days by judges, lawmakers, prosecutors, and voters alike.